Hello, everyone. Before we dive deep into the world of legal studies, it's highly recommended that you have a pen and notebook ready to take necessary notes for your learning journey. Please note that there will be a disparity between the visuals and the audio points. For an accurate interpretation, I would appreciate if you could prioritize the audio content only. Remember, if there's anything you don't understand, feel free to pause the video, rewind, and watch or listen again. We are diving back in and explore again the brilliant ideas of John Austin once more. Now, get ready to learn, take a deep breath, and here we go. John Austin's Analytical Jurisprudence, the separation of law and morality. The study of law, beyond the mere memorizing of rules and statutes, involves a deeper intellectual discipline known as jurisprudence. Essentially, jurisprudence is the theory, philosophy, or science of law. It seeks to answer fundamental questions such as what is law and what is the relationship between law and justice. Among the most influential thinkers to tackle these questions was John Austin, 1790 to 1859, an English jurist whose ideas laid the foundation for the school of thought known as Analytical Positivism. His contribution was a radical and lasting redefinition of the scope and subject matter of jurisprudence, which centered on the concept of positive law. Now we're diving into the discussion, which focuses on positive law, laws strictly so called. Austin's primary and most revolutionary assertion was that the science of jurisprudence must be exclusively concerned with positive law, which he termed laws strictly so called. To Austin, law is fundamentally a command issued by a sovereign, a powerful figure or body, backed by a sanction, a penalty, for non-compliance. This definition is purely descriptive. It does not concern itself with the moral quality or ethical content of the command. For jurisprudence to be a true science, Austin argued, it must maintain a strict separation between law as it is and law as it ought to be. This is the core of legal positivism. By confining the study to positive law, the rules actually laid down by human superiors for human inferiors, Austin sought to create a clear and objective field of study free from the subjective messiness of moral or religious judgments. The goodness or badness of a law, its fairness, or its alignment with natural justice are, in Austin's view, subjects for ethics or morality, not for the legal scientist. Jurisprudence's task is merely to analyze the structure and concepts of the law that exists. Let's look at an example of the traffic law and Austin's view. Imagine a city law that requires all drivers to stop at every intersection, regardless of traffic or signals. Austin's view of jurisprudence, which focuses only on positive law or law as it is, would strictly analyze this rule. The command is to stop, the source is the city legislature, here the sovereign, and the consequence is a 100 rupees fine, the sanction. Crucially, the legal scientist following Austin excludes any judgment on law as it ought to be, meaning they do not consider arguments like this law is bad because it wastes fuel, or a better, more fair law would only require stopping at busy corners. Austin insisted that such moral or policy-based discussions must be kept separate from the actual science of law itself. Now we will discuss Austin's classification. General versus particular jurisprudence. Having established that jurisprudence deals only with positive law, Austin proceeded to divide the subject into two distinct branches, general jurisprudence and particular jurisprudence. This division was not arbitrary. It was based on the scope or range of the legal materials being studied. So we will now discuss about particular jurisprudence, which is the science of a single system. Austin defined particular jurisprudence as the science of a particular law. It is confined to the study of any actual system of law or any portion of it, meaning the law as it exists in a specifically determined political society. Its data is drawn exclusively from one state's legal system. Here, at this point, we have to discuss the scope and nature of particular jurisprudence. In Austin's words, particular jurisprudence is the science of any actual system of law or any portion of it. The only practical jurisprudence is particular. This branch is dedicated to describing, analyzing, and systematizing the positive law of a single community. For example, the law of India, the law of France, or the law of the Roman Empire. Its principles are inevitably colored and shaped by the concrete details of that specific system. If a student is analyzing Indian contract law, they are engaging in particular jurisprudence. Let's look at an example of particular jurisprudence in action. This example demonstrates particular jurisprudence, which is the study of a single specific legal system. Imagine two different scholars examining contract formation. One scholar studies Indian law, which requires the element of consideration, something of value exchanged, to form a valid contract, focusing only on Indian court precedents and laws. The other scholar, studying German contract law, specifically the BGB, finds a completely different requirement. Consideration is not necessary. Instead, a contract is valid based on a meeting of the mind's consensus and the intent to be legally bound. Both scholars are practicing particular jurisprudence because their research is confined to the specific concrete rules of a particular legal system, India or Germany, rather than searching for principles common to all legal systems. Another example is a scholar focusing on particular jurisprudence might choose to analyze English land law. They would study the specific historical concepts like fee, simple, absolute in possession, and the specialized rules governing easements and covenants as defined solely by the statutes and court rulings of England and Wales. This research ignores how land is owned in France or Brazil. Its data, principles, and scope are entirely confined to the particular system of English law. Another example is the study of criminal defense. A jurist could conduct an analysis of the law of self-defense in the state of Texas, a specific part of the US legal system. This research would be confined to the Texas Penal Code, focusing on the unique circumstances and statutory criteria, like the Castle Doctrine provisions, that legally justify the use of force within that state's jurisdiction. The scholar would not compare it to the self-defense laws in Japan or Canada. Their focus is strictly on the particular law of Texas. The study in each case is particular because the principles are tied to the specific rules and history of that single nation's system. Now it is time to focus on general jurisprudence. The universal notions. General jurisprudence, or universal jurisprudence, is concerned with the exposition of the principles, notions, and distinctions which are common to all systems of law. It seeks to identify the fundamental elements that underlie all legal systems, specifically those that are ampler and maturer, and therefore preeminently pregnant with instructions. Now we have to learn the search for commonalities in general jurisprudence. The core purpose of general jurisprudence is to expound the fundamental principles and broadest generalizations that can be observed across two or more established legal systems. These resemblances are believed by Austin to be bottomed in the common nature of men or correspond to similar needs and structures in different political societies. It is pure or abstract jurisprudence because it analyzes these essential elements without special reference to the institution of any particular country. The goal is to create a scientific framework, a set of universal concepts into which all specific rules can be logically sorted. Now, a practical example which discussed the concept of right, general notion. In general jurisprudence, the science abstracts the concept of a legal right. It analyzes the common elements: a person who possesses the right, the subject; a person who is obligated, the object of the duty; and the act of forbearance to which the subject is entitled. This definition is purely abstract and applies equally to a right to property, a right to bodily integrity, or a right to payment. Now, what it avoids. The specific rules about how a right to property is registered in India versus how it is transferred in Australia. The focus is only on the concept of a right itself. Another practical example is the idea of ownership or property. In general jurisprudence, an analysis of ownership identifies the core powers that typically accompany it: the right to use, the right to exclude others, the right to dispose of the thing, and the right to the income from selling fruits or other things. These common ideas are found in nearly every sophisticated legal system. What it avoids: debating whether the Indian Transfer of Property Act differs from the English common law concerning the formalities of a mortgage. Now we will learn about the relationship between the two. Austin clearly stated that general and particular jurisprudence differ from each other, not in essence, but in their scope. In both cases, the ultimate subject is positive law. The difference is simply in the breadth of the data analyzed. General jurisprudence takes its data from the systems of more than one state to find the common denominator, while particular jurisprudence restricts itself to the data from a particular system of law. Let's now have something that explaining the concept of possession. The upcoming example itself uses the concept of possession as a key example to illustrate the distinction. In general jurisprudence, the scholar analyzes the abstract concept of possession. This involves identifying its two essential elements, which is found everywhere: corpus, which is physical control over a thing, and animus, which is the intention to hold the thing as one's own. This analysis is done without reference to any specific law. In particular jurisprudence, Roman law, the scholar analyzes possession specifically within the context of Roman law. They study how Roman courts distinguished between possessio civilis and possessio naturalis, the specific methods of acquisition and loss under Roman law, and the unique Roman remedies, interdicts available to protect possession. The focus is concrete and local. A practical example on the concept of crime or wrong can be stated in this way. In the general jurisprudence, the analysis focuses on the general distinction between civil wrongs, torts, and public wrongs, crimes, which is common to many systems. A crime is generally defined by the fact that the state prosecutes the wrongdoer, while a civil wrong is resolved by one individual suing another. In the particular jurisprudence, UK, the scholar analyzes the specific statutory definition of theft in the UK's Theft Act 1968, detailing the particular mens rea, guilty mind, and actus reus guilty act required by that specific legislation. Now, criticism of Austin's classification. Despite Austin's rigorous attempt to bring scientific clarity to jurisprudence, his classification was heavily criticized by later jurists, most notably Sir John Salmond and Thomas Erskine Holland. The main contention against Austin's division was based upon its impracticability and a belief that it misrepresents the true nature of legal science. Salmond's criticism targeted Austin's assumption that a legal principle had to be common to many legal systems to be part of general jurisprudence. Salmond argued that this was an error. Salmond's criticism says jurisprudence is one. Now we will learn how jurisprudence acts as an integral social science. Salmond contended that jurisprudence is one integral social science, not a collection of different kinds of jurisprudence. He stressed that while there might be many schools of thought, schools of jurisprudence such as analytical, historical, or sociological, there are not different kinds of jurisprudence itself. The science remains the same, only the subject matter, the system of law under review, changes. Salmond stated that it is incorrect to use terms like Hindu jurisprudence, Roman jurisprudence, or English jurisprudence. What we are truly dealing with in these cases are not different sciences, but different systems of law. The proper term is simply jurisprudence without any qualifying epithet. Jurisprudence is a social science that studies social institutions like marriage, contract, property, from the point of view of their legal significance. One practical example on the nature of the legal science, or the doctor analogy. In Austin's view, the classification, Austin is like saying there is a general medical science that studies the concepts of disease and cure abstractly, and a particular medical science of India that only studies diseases found in India. In Salmond's view, the unity, Salmond is like saying there is only one medical science, medicine. A doctor who studies diseases in India is still practicing medicine. They are simply applying the universal principles of medical science to a particular set of patients' data. The science itself is universal. Now we have Holland's criticism. Material is particular, not the science. Holland's criticism, often considered the most penetrating, focused on the idea that the particular study of a legal system is not a science at all. Holland argued that it is only the material which is particular, not the science itself. He famously used the analogy of geology. In the geology analogy, Holland pointed out that a science is a system of generalizations that, even if derived from observations over a limited area, will hold good everywhere, assuming the subject matter possesses the same fundamental characteristics. Holland's argument, a science is a system of generalizations which, though they may be derived from observation over a limited area, will hold good everywhere. In geology example, principles of geology developed from studying the rock formations of England alone, a particular area, will be true all over the globe, provided the same fundamental substances and forces, erosion, heat, pressure, are everywhere present. The geology of England is not a separate science. It is the application of the single science of geology to the data of England. In law application, Holland argued the principles of jurisprudence is similar if derived entirely from English data, a particular system, would still be universally true if applied to the law of any other community of human beings, provided those human beings resemble the English in essentials. The study of English law is merely the material used for the science, not the creation of a particular science of English jurisprudence. A practical example on the law of negligence, Holland's point, in particular study, the material. A lawyer studies a specific English court case, Donahue v. Stevenson, the snail in the bottle case, which established the modern law of negligence and the neighbor principle. This is a particular rule from a particular system, English law. In Holland's interpretation, the science, the principle itself that a person owes a duty of care to their foreseeable neighbor is a universal concept. The science of jurisprudence extracts this universal principle duty of care and applies it to analyze a specific system. The science itself remains universal even if its material started in England. Now we will learn about the historical school's rebuttal. Law is not like geology. Holland's criticism, while logical, rested on a crucial assumption that law has the same fundamental characteristics all over the world, just as chemical substances and geological forces are universal. The historical school of jurisprudence, led by thinkers like Maitland and Savigny, sharply rejected this assumption, arguing that law is a unique cultural product and not a mechanical science. Now we will learn law as growth and culture. Maitland pointed out that races and nations do not travel by the same roads and at the same rate. Law is not a static universal structure. It is deeply intertwined with the history, spirit, and social needs of a people. According to Lord Bryce, he emphasized that the law of every country is the outcome and result of the economic and social conditions of that country, as well as the expression of its intellectual capacity. Law is molded by its context. According to Buckland, he stated that law is not a mechanical structure like geological deposits. It is a growth, and its true analogy is that of biology. Law grows and evolves organically with the society it governs. According to Savigny, he asserted that law grows with the growth and strengthens with the strength of people, suggesting that law is a reflection of the common consciousness or spirit of the people, known as Volksgeist. This counter-argument suggests that Austin's attempt to isolate a set of common abstract principles is flawed because the law's fundamental concepts are so heavily influenced by unique national histories that true universal principles may be shallow or non-existent. Now we will have a practical example on the law of land ownership, Maitland's point. We will talk about the difference first. The law of land ownership in a highly communal, tribal society where land belongs to the entire community is fundamentally different from the law of land ownership in a capitalist, Western society where land is bought and sold as private, absolute property. This is a difference. Now the implication. The core concept of ownership in the two systems is so different. One being communal trusteeship, the other being absolute private power, that any general principle Austin extracts might be too vague to be meaningful, or it might falsely impose the Western concept onto the tribal one. Let us now learn ambiguities and lack of practice. Finally, the classification was criticized for its inherent ambiguities and for Austin's failure to adhere to his own stated method. Dias and Hughes pointed out serious flaws in Austin's definition of general jurisprudence. First is lack of criterion for maturity. Austin provided no clear criterion for what constitutes an ampler and maturer system of law. This led to accusations that he simply chose systems, like Roman and English law, that suited his preconceived notions. Second is ambiguity of common principles. He failed to explain whether the common principles he sought were those in fact found to be common, that is to say, empirically observed, or those which for some reason were treated as being necessarily common, that is to say, a rational deduction. Third is failure in practice. The most damaging criticism, noted by Buckland, was that Austin and others who profess general jurisprudence did not adhere to it in practice. When one looks at the substance of Austin's own major work, The Province of Jurisprudence Determined, it is largely drawn from a detailed analysis of English law with only occasional references to Roman law. His jurisprudence, despite his intentions, was essentially particular, or at most comparative, rather than truly universal. Now let's have a practical example on the problem with Austin's data set. I will define the general principle of trust by looking at all mature legal systems, is Austin's claim, but in reality, the criticism. Austin's work defined trust primarily based on the unique concept of the common law trust developed by English equity courts. He then treated this particular English concept as if it were a universal legal notion. In reality, many mature legal systems, especially in civil law countries like France or Germany, have no exact equivalent to the common law trust. They use different mechanisms for asset management, like foundations or mandates. This failure showed that Austin's general jurisprudence was often just a generalization of a particular system, English law. Now, conclusion. The lasting impact of the debate. While John Austin's division of jurisprudence into general and particular was logically precise, it quickly became highly controversial and ultimately deemed unsustainable by many subsequent jurists because it strikes at the core question of what law truly is. Austin, a positivist, believed law was a self-contained, universal science that could be studied objectively, entirely separate from its specific national background. However, his critics, often from the historical or sociological schools, strongly argued that this universal science was an illusion. They contended that law is an organic, cultural, and political phenomenon that is inextricably tied to the unique history and social conditions of the nation it governs. The main consensus today leans towards Salmond and Holland. Jurisprudence is one single science that uses different systems of law, the materials, to derive its universal concepts, but acknowledges the historical school's point that the principles are heavily colored by the unique social context of the law-giving authority. Austin's primary victory was not in his classification, but in his insistence that jurisprudence must first and foremost focus on positive law, thereby establishing analytical positivism as a dominant force in legal philosophy. That's all for now. Thanks for watching the whole video. If you enjoyed it, please comment in the comment section below. Jurisprudence with Austin is wow. Hit the like button, share it with your friends, and do subscribe to the channel, Knowledge Drops 3. Also, don't forget to click that notification bell so you'll know right away when I upload a new video.